Hi, this is Ty Vomsal, and this is my EDL 853 presentation when a student's rights are wrong. So to summarize the case, this case involves the principal, counselor, and a student at a school who has recently become paralyzed, as well as his parents, Mr. and Mrs. Hernandez. Miguel, the student, was the school's star quarterback for their highly successful football team. He's also a dedicated student who is highly invested in his education and is involved in a variety of college preparation programs. A traumatic injury that he sustained during a high school football game has left Miguel paralyzed and in need of a wheelchair and accommodations in order to resume his class schedule. Upon being medically cleared to return to school, a short meeting was held to discuss accommodations for Miguel to ensure that he has access to a free, appropriate public education. Access to classrooms was the only accommodation agreed upon before Miguel was cleared to return to school. Once Miguel returned to school, he was informed that his class schedule has been changed because his biology class does not support or have wheelchair access. The new science class he was put into is not a college preparation class. After hearing the change, Miguel's parents requested a meeting with the principal and brought an attorney to advocate for Miguel's rights. To discuss legal and ethical issues involved in this case. Has anyone been harmed? The educational rights and potential by the student, Miguel, has been harmed by losing access to a college preparatory class due to a lack of access to the physical space. The reputation of the school or the principal or the counselor, Ms. Guzman, may be harmed by not providing appropriate accommodations that were outlined. It could also present legal issues as well if accommodations are not deemed reasonable to address IDEA and FAPE. Does the situation contravene existing laws? Yes. The violation of the student rights under IDEA and Section 504. Being denied the rights to a class because he is no longer able to access it is a violation of both of those. It also violates the Americans with Disabilities Act, which is just stating that civil right law prohibits discrimination solely based on a disability. It is also a violation of FAPE under the new classification of providing accommodations. The newest court case, Andrew versus Douglas County School District, stated that accommodations cannot just be the bare minimum and must be appropriate for individual student abilities. So even though the accommodation provided was to still address science credits, it was not being addressed in a way that was appropriate for the individual student's abilities. Miguel is still 100% capable of continuing on with his regular class schedule and should not have to move from a college preparation biology class that he needs to go to college to a lower level one just because he has lost access to the physical space in which the class is held. As far as breach of contract, discrimination, or harassment, discrimination has occurred due to the lack of access to the biology course. Denying a student access to a college preparatory course and not allowing wheelchair access to lower level courses is a violation of ADA and is not providing reasonable accommodations and access to a free, appropriate public education. So to synthesize the situation, as a principal, I'm in a tough situation. I have a student who is in need of accommodations due to recently becoming paralyzed during a school sport. I do not have a school that is accessible to provide the necessary accommodations in order to provide a free, appropriate public education that will support the equitable access to educational resources, technologies, and opportunities that support the educational success and well-being of the student, and could potentially face legal action if a solution is not reached to provide access to college preparatory programs. To synthesize a little bit more of the specific information, the people involved are the principal and counselor of the school, Ms. Guzman. Miguel Hernandez, he is the student. He's a sophomore and student in need of the accommodations. Mr. and Mrs. Hernandez are parents and legal guardians of Miguel. And then Mr. Carey is the Hernandez family attorney representing the rights of the student and family. The place that this is occurring is Nottingham High School. It is an older school. It's still in need of renovations. About a quarter of the school is not up to code. The school serves 3,200 students, as it is the only high school in Dover School District. And then the community that that surrounds the school is supportive and engaged in the school. They have a high level of academic achievement throughout the entire district. The program is the public school in the district of Dover School District, and more specifically, the program involved in this case is the biology class that Miguel is trying to remain in. It is a science class that qualifies as a college preparatory class and is also a requirement for the college program that Miguel is interested in going to. So by losing access to it, he's not going to be able to meet all of the requirements to be able to attend the college that he is interested in. To review information, some things to consider. The stakeholders and stakeholder issues. So the stakeholders involved are, again, the principal, Ms. Guzman, Miguel Hernandez, Mr. and Mrs. Hernandez, Mr. Carey, the biology teacher, and then by default, the community as a whole. The scenario could pose issues for a lot of stakeholders involved. The principal's reputation could be damaged by legal action over providing accommodations. Miguel's educational success and well-being is not being supported by a loss of access to college preparatory class. Ms. Guzman's job and reputation could be damaged by legal action and the inability to provide accommodations for free and appropriate public education. And then the community as a whole could be impacted by the outcome of this decision. With the amount of support that we can assume there is for the school in the community, the amount of involvement, a legal battle over education could create tension within the supportive and involved community as a whole. And involvement from the community could create larger issues for the school, the principal and teachers and counselors, and the entire school community if this situation is not resolved and the Hernandez family is able to rally the community behind them to support them. That could create a lot of issues inside of the school. Other things to consider, the stakeholder consultation and impacts. Currently, all stakeholders have not been consulted in the proposed scenario. As presented, the stakeholders who have been in play up to this point are the student, Miguel, Mr. and Mrs. Hernandez, Howard Carey, the attorney, and then Ms. Guzman. Right where the situation or the scenario starts, the principal has just been informed of the situation, hasn't really had a chance to really have an impact or any say in how this is going. So that's kind of the scope of where we are starting from. And other stakeholders to consider involving would be potentially the superintendent of the school district, any integrated services teams or providers that are at the school that have a little bit more experience with accommodations, IEPs, and all of the legal components that have to go with that. The current biology teacher of Miguel, and then the new science teacher, or even the entire science department, could be stakeholders that could be in play depending on what kind of decision and what direction the principal decides to go with to remedy this situation. Other things to consider about facts and information. What additional information would be nice? The information presented is very early on in the process. Based off of the information presented, there's ample evidence to suggest that there is a variety of different actions that could be taken to remedy it. But still, additional information would be nice in order to make a more informed decision. Some of the additional information that could be beneficial to know was if Miguel was ever put on a formal IEP or 504, or if the only accommodation was access to a classroom and that was more of just a conversation and not like any sort of like written, documented, anything like that. I'd like to know what the principal's role has been in this IEP process, if this was just something that was handled solely by the counselor, or if there were other individuals involved in the process, or maybe it was just her kind of going with what she felt. It'd be nice to know what the school's plan is or budget for the building renovations. Again, about a quarter of the school is not up to code, and clearly based off of the scenario, you can assume that this biology classroom would be one of the quarter of the school that is not up to code. Otherwise, we wouldn't have an accessibility issue. How many areas of the school are not up to code? just trying to get an idea of like what is the potential for more issues in the future, especially if there's just a short-term solution that is provided for Miguel for this semester, this specific class. Are we going to run into the same problems again next semester, next year, with any of his future schooling? As you know, he is only a sophomore. He still has a couple years left at the school. And then what other science options are there? Is there a different biology class that maybe meets at a separate time in a different room that's more accessible? Is there online technologies options? Obviously not as ideal as like a face-to-face classroom setting, but is there something that still meets those college preparatory requirements that can be taken like online in a variety of other areas so that it can kind of do away with that accessibility issue? Or is there an option for moving the class to a more accessible room? You know, all of this information would be nice to know, but I do think that there is enough information presented that you could make a reasonable decision on how to proceed in this situation. So my options for decision, I came up with four different things that a principal could do in this situation to fix this problem. Number one, do nothing. You can claim that providing an alternative science class meets the accommodation needs, and you can prepare for legal battle and just know that it's probably not going to be a fun or a short process. Option number two would be more of a cooperative approach. You can ask the science teachers, meet with the whole department, and just kind of see if you can switch classrooms around to move this biology class to an accessible classroom if there is one available. Option three would be kind of a band-aid approach. You can look into installing temporary ramp or other accessibility equipment to provide accessibility to that specific biology classroom for the rest of the semester, while waiting for and trying to look into building upgrades to help to just meet accessibility requirements for the long term. And then there is a comprehensive approach where you can meet with all stakeholders, Guzman, Miguel, the family, attorney, and all other stakeholders. You can discuss a variety of options for other classes that can be used immediately without sacrificing educational opportunities. You know, maybe instead of going to a lower level class, we can push Miguel up into a higher level one that still meets those needs and addresses that college preparation requirement. So just coming prepared with a variety of different opportunities and options, and trying to discuss and come to a mutual decision, while also, you know, pitching some of those previous approaches that I have discussed. Additionally, in this option, I would want to review and retrain all staff on ADA and FAPE, and then also work on getting the building up to code immediately in order to, again, avoid future issues for this same situation. So, to evaluate these options, option number one for doing nothing, claiming that providing an alternative science class meets accommodation needs and prepare for legal battle. One of the pros is that it creates the least amount of work for all school-related stakeholders because it's kind of already done. That would just be the end of at least the scheduling work, but obviously there's a much larger list of cons for doing nothing to remedy this situation. So cons would be it's a violation of ADA and FAPE laws and demonstrates a lack of interest in being accommodating to all students throughout the district. Not a great message to send to an incredibly supportive community. It will lead to legal action from Mr. and Mrs. Hernandez and their attorney. Whatever direction they want to go with that legal action has a variety of unique challenges, but none of them are positive things that I'm sure the school would want to engage in. And then another con is obviously Miguel's needs would not be met. It does not support the educational success and well-being of the student. And ultimately, as a building leader, a principal, that's what your job is to try to meet all of the needs of all of your students and support their educational success and well-being. So, not a fantastic plan.